commend this bill to the House.
I call Dennis O'Rourke.
Thank you, Mr Speaker. The government was right this year to review the family court, and this bill, as we know, is the outcome. It is an omnibus bill amending several acts dealing with children and families. Family cases, especially those dealing with the custody of children and related issues, are taking up a rapidly increasing amount of court time, and they are taking up a very large share of the legal aid vote. Many cases are not really suitable for the court and do need mediation and rather than determination if possible, if practicable. There is very little benefit for families or children where there is unnecessary resort to the courts, where the family itself can best sort out their issues with some help. Some separated spouses, by the way, not entitled to legal aid, are being intimidated by the other spouse who can get legal aid by resorting to the family court when a dispute can be better resolved by mediation and agreement where appropriate and practicable. The thrust of the bill, therefore, is to encourage faster and less expensive resolution by requiring parties to participate in a new out-of-court resolution process and in a parenting information program before going to the family court for a parenting or guardianship order. But, Mr Speaker, that will only work if these services are well resourced and are accessible, and in particular if they are not too expensive. And that is the challenge for the government to demonstrate through the next phases of this bill. It is wise, however, to focus on the family court on matters genuinely needing a court decision, where protection of vulnerable people and children can be properly prioritised. It is also positive that an objective of the bill is that family court cases be less adversarial in their proceedings. But, Mr Speaker, that is easily said. It's not, of course, quite so easily done. It is right and more beneficial for parties to take responsibility for their own arrangements with the assistance of the court concerning the care of children where possible. And this also has upsides for the children and the family. Children never profit from sometimes acrimonious and pointless family disputes, especially over parenting and guardianship. Family disputes can be easily entrenched and worsened by making it too easy to get to the court. Requiring a genuine resolution by way of mediation will help that situation, but of course the court must always be there as a backstop. Another objective of the bill is to try to make the family courts more responsive to victims of family violence, and that is a worthwhile objective. The new requirement for a mandatory out-of-court resolution process does not apply to family violence cases, so that they can still go straight to the court. And that is necessary and a good use of the court's time. Also, the bill expands the definition of psychological abuse and increases maximum sentences for this from 2 to 3 years and improves delivery of mandatory non-violence programs. I think those are welcome measures. Overall, the result should be to make the family court more efficient and cost-effective by refocusing its resources in those ways, and it should speed up court applications by reducing the court's rapidly increasing workload. But, Mr Speaker, this must never be at the expense of access to the courts or because of excessive expense. Now, the issues and matters that I believe still require discussion in the next stages of the bill will first and foremost be the cost of the out-of-court resolution processes. As I've said, these must not be an excessive barrier, and it should be reconsidered by the government because $1,000 is far too much as a cost for those alternative processes, even if legal aid is available for for that purpose. Secondly, the bill targets the use of professionals, especially lawyers for the parties and lawyers appointed to represent children separately. That is also going to need further investigation, and New Zealand First will never agree to penny pinching resulting in lack of adequate legal representation where it's really needed. The legislation must be even-handed and not unfairly empower a party having greater economic resources than another. I therefore welcome the Minister's commitment to get it right, and I hope he will listen to some of these concerns. The bill requires parties to contribute to the cost of expert reports and witnesses in some circumstances, and I agree that it is currently too easy for parties, especially those on legal aid, to get expensive and sometimes unnecessary expert reports. But this has to be balanced against the cases where such reports are really needed. This too needs further discussion so that where a matter goes to the court, it is not hamstrung by inadequate expert evidence. The bill requires the courts leave for new proceedings where it has been less than 2 years since the last similar application. This is to discourage repeated applications for parenting and guardianship orders, especially when a party can get legal aid. And, Mr Speaker, I'm personally aware from my own experience and practice and as a previous member of the Legal Aid Review Panel, I'm aware that this has been a problem. And so New Zealand First will certainly support this aspect of the bill. But this is a large bill with many technical issues to examine in later stages. We think overall it is a good bill. The devil will be in the detail, and in particular in the costs that it will impose for those out-of-court processes. The bill will fail if that is not reviewed, because $1,000 is grossly too much, and that is not good enough. New Zealand First would have to reconsider its support if that is persisted with. We wish to examine all of the detail in the bill in its latter stages, but is happy to support the bill because of its overall thrust at this stage. But, Mr Speaker, that will be on the condition that the issues I have mentioned are adequately and sincerely dealt with by the government, who must listen to some of the concerns that we and these parties on this side of the House have expressed. So with those conditions, with those reservations, New Zealand First will at this stage support the bill.
I call Mike Sabin.
Thank you, Mr Speaker, and I thank the member resuming his seat for his contribution. I can't say